SJC-11610, Commonwealth versus Cologne.
Thank you. Mr. Rasile, good morning.
Good morning, Mr. Chief Justice, members of the Supreme Judicial Court. I'm Attorney Jim Rasile, appearing on behalf of the defendant appellant Dennis Cologne. In this case, in performing its function to assess the voluntariness of Mr. Cologne's June 23rd statement, the one that was given at the Lawrence District Court, the morning after he had been arrested for the unrelated gun charge, the jury was not made aware of many important circumstances that could have been and should have been brought to its attention in order for it to do its time-honored important function of weighing the totality of the circumstances and assessing the voluntariness or lack thereof of that June 23rd statement. The jury in this case were not told that at the time that he was arrested on June 22nd, Ms. Castro, his girlfriend, the two of them were romantically involved. They lived together, maintaining a home with her and her kids. In fact, they were expectant parents of a set of twins at the time that this happened. The jury was not told that when he was arrested, she also was brought down to the station at the same time. They were not told that she was not under arrest, nor were they told that her 15-year-old son, walking home from school on June 22nd, was also asked to or also brought down to the police station. They were not told that each of those three individuals, Mr. Cologne, Ms. Castro, and her 15-year-old son, were each kept in separate rooms at the Lawrence Police Station. The jury was not told that she was questioned in a coercive and intimidating manner, and that the police may have played upon her emotions to a certain extent. They were not told that she was in an emotional state when the police had made her aware of the fact that her teenage son was also at the station. They were not told that at the same time that that was going on, Mr. Cologne was being interrogated elsewhere for the gun possession charge and also as a person of interest in an open murder investigation. They were not told that the questioning of Mr. Cologne occurred in two recorded sessions that were made before and after an unrecorded telephone call to him from Ms. Castro that was orchestrated by Detective Brooks, who was the lead investigator, at least in the gun charge, but also took an instrumental role in the investigation of the.
So how do you, the trial judge finds that this phone call is brief and that there's no communication between Castro and the defendant about the coercive tactics used against Castro. How do we undo that?
Your Honor, I would readily say that I don't think there's any question that she did not, during that orchestrated phone call to the officer's cell phone while he's being booked, that she probably did not say, "The police are telling me that I'm going to give birth to our twins in jail and I'm never going to see them again." She probably did not say, "I just saw my 15-year-old son. He was brought in for a few seconds and left, and I was told I'm never going to see him again." She was not told all the specifics.
But that hurts rather than helps you, doesn't it?
Respectfully, Your Honor, I would say that under the circumstances, given the circumstances that prevailed at that time, as it was described post-verdict at the new trial motion, that clearly she was upset. She was crying. The defendant himself was crying. The trial judge, Judge Welch, so found in those findings. The judge found that she asked the defendant during that call, asked Mr. Cologne, cooperate with the police, get yourself home. She was upset and crying, and as he was as well. I would respectfully suggest, Your Honor, that within a matter of a few seconds, the tenor of what was going on and everything that he had to know that she had to communicate was communicated right at that point. And indeed, if...
What does he do? Because they're two separate... what does he do after that? He makes the really incriminating stuff, right, comes the next day, right?
The incriminating stuff vis-a-vis the murder charge, yes, Your Honor. What he did do he did start some incriminating stuff after the phone call. The first statement, they turned the recording off at 4:23 p.m. on June 22nd. The second taped recording recommences or commences at 5:31 p.m. And at that point, Mr. Cologne now is giving his correct name. He had given a false name the first time, and he clearly implicates himself in the gun charge.
Do you think he knows he's implicating himself? I mean, you know, I think the theory is that the conversation with his significant other, whether the police were engaged in what there's been a suggestion they were or not, that the conversation has her so upset that it has him so upset that his statement to the police isn't voluntary.
Yes.
Okay, and my question is, do you really, what he's admitting to, does he really understand that that's an inculpatory statement at the time he's making it?
We're talking the statement, the second one on June 22nd, in which he inculpates himself vis-a-vis the unrelated gun charge.
Meaning the possession of the Beretta.
Exactly, Your Honor.
And it was the next day that he said, I was outside in the hallway.
Yes.
Okay.
And so what you see when you listen to the tapes, and those are submitted as part of the record appendix, the last item in the record appendix is one CD to allow you to listen to those, you can clearly see the progression of exculpatory, lack of cooperation with the authority, and as it changes, and then overnight, when he's at the Lawrence police station, and he, in fact, summons the Detective Sergeant Burke, who's investigating the murder, he summons her over and is now going to make implicating statements vis-a-vis as a lookout.
I guess this is what I'm trying to say. I mean, he's concerned he's in jail. He's got probably whatever he knows he's got, maybe he's facing on this gun charge. And then, you know, he wants to get out, and he brings the police over, and, you know, he doesn't have the restatement of what aider and abetter is, and he's sort of saying he's the lookout. In order to say that the statement's not voluntary, there has to be some sense that he's saying something he really doesn't want to say, that it's not of his free will. It seems to me, and I might be wrong about this, all I read were the briefs. It seems to me that he might be thinking he's helping himself when he's making this comment the next day. Do you understand my question? Does that fit with the transcripts and the evidence?
If I may, I respectfully suggest
Yeah.
that when you listen to the tapes, you will see during the first conversation on June 22nd, the one that ended at 4:23 p.m., the first 8 minutes of that recording is devoted just to the gun charge. And then, for whatever reason, they then switch in with Detective Sergeant Burke into questioning about the Caba murder. And he proceeds to give details about the Caba murder, and he is identifying other people that he's heard on the street were responsible for it, but he doesn't implicate himself at all. And that occurred for the final 14, 15 minutes of the first statement. That was it. The other thing, to put it into context, if I may, and I think one overriding theme that has to be taken into account here is the way that this issue is being presented to this court. This falls right in line with our humane practice standard. I mean, the principles that the Massachusetts rule as far as the humane practice, that's what's being involved here. But it's not in your typical way of it being presented to you. It's being raised in the context of a Sixth Amendment, Article 12, ineffective assistance to counsel. And so what I asked the court to keep in mind during all of this is to understand what could have been presented to his jury at the time in order for them to really weigh the full totality of the circumstances.
But if the judge finds that the actual communication is brief because he's at booking and doesn't communicate anything more than that she's upset and wants to go home and he should cooperate and go home, that isn't enough to get you over the voluntariness hump, is it?
Justice Kafka, I am not arguing here today that this statement that he gave on June 23rd was indeed voluntary. This case is not like your decisions in Monroe or Bay or Tremblay, where what you're asked to focus on is the voluntariness or lack thereof of the statement associated with police tactics of questionable stature. That's not what we're doing here, but you can certainly, it's akin to that. In this case, what I asked the court to keep in mind during all this is that what was not presented to the jury did not have the opportunity. They didn't know about the phone call. They did not know about the questioning of Idalia Castro that had preceded the phone call, that she testified to under oath pre-trial.
Well, so we got this issue because Mr. Sobelman and Mr. Ranta testify at the motion for new trial. Well, I didn't do it because I didn't know about it. And so there's two ways to look at that, I suppose. One is they didn't know about it because they didn't, I'll take your way to look at it, if I understand it right. They didn't know about it because they didn't investigate it, so the jury never got to evaluate during the trial why the defendant's statement under humane practice would have been involuntary, or they didn't know about it because they were never told about it because it didn't happen that way. From the Commonwealth's perspective.
You refer to it as my way here, Your Honor, and so I'll, in commenting on that, what I'd call to the court's attention is in Record Appendix at pages 83 to 85 is the 3-page police report that was prepared by Detective Brooks that the trial counsel said he was there. And in that police report, it documents the efforts of the actions of Detective Brooks to have what we call orchestrate the phone call. He actually says in the police report, I directed Sergeant Detective Burke to have Idalia Castro call my cell phone, my being Brooks' cell phone, in the booking aid. And so he gets the call and says, here, it's for you, and the defendant hears her voice for a few seconds.
So the investigation by the lawyer should have turned that up.
Exactly. In fact, it appears that the first time he ever spoke, he being trial counsel, ever spoke to Idalia Castro was 6 days before trial, on June 6, 2011. And then she proceeded to recount quite a story that was credible. In fact, trial court Judge Welch actually acknowledged some credibility, some of her points that she was raising. He gave her credence that she was 4 months pregnant, she had been crying, and so forth. So our contention is, had that evidence been presented, what she testified to pre-trial, as far as the motion to eliminate, because she was pleading the fifth, that happened pre-trial. Had the jury heard that, also heard the defendant, his testimony of what happened at the police station, just a few seconds of a phone call, but enough to make both parties upset under the circumstances, heard testimony about the unusual nature of a defendant being booked, getting a cell phone call like this in this fashion. What would this jury have done? Now,
Excuse me, did you just say she took the Fifth Amendment?
oh yes,
She couldn't have testified.
She had given a statement on June 23rd also that inculpated Mr. Colon. Now she's coming in as a prosecution witness, and she's saying, whoa, I was forced to give that particular statement. And she recounts a story of what happened to her at that police station for the first time 6 days before trial to trial defense counsel. At that point, he prepares pretrial motions to keep her testimony from coming in. And in fact, he suggests to Judge Welch, she's got a Fifth Amendment privilege because she's going to recant what she told the police. And so Judge Welch conducted a pretrial hearing, appointed counsel for her, and ultimately determined she did not have a valid Fifth Amendment right because the statement that she gave on June 23rd to the police, she did not give of her, it was not a willful violation, it was not willfully done, and so that abated any suggestion that she'd be criminally prosecuted for giving false testimony to a police investigation. So pre-trial, Judge Welch gave credibility and credence to what she was testifying to about the heavy-handed tactics that she was being subjected to before she gave that June 23rd statement.
So you're saying she's available to testify?
And then it made her available to testify.
Did she testify?
No, the next morning, the Commonwealth announced, we're not going to call her. And she never testified at trial.
I'm not sure that.
And
The defense
and
counsel
so,
knew about- but at this
but
point,
I,
the defense counsel knew about the testimony.
he did. And he also had, right in his file, a police report that said she had called him at the station in between those statements on June 22nd, the day before, and never made inquiry about what was the nature of that call. What happened during that call?
Didn't you say she just testified that before the judge as far as the first Fifth Amendment privilege? I guess the defense counsel would not have been there for that, right?
I think that's correct, Your Honor.
So that's not how he would have known about it, I guess I was saying.
No, he would have known about the phone call because it was on the police report.
I understand that, but he wouldn't have known what the conversation was.
No, but he would have known. It appears as though he first spoke to her 6 days before trial.
Okay,
And at that point, recounts quite a story of.
so he knows
Heavy-
about it at this point. He knows about it. He knows about the conversation that she's had with the
Well,
police and.
What he does know, I think the record would be fair to say that what he does know, 6 days before trial, she recounts a story of the heavy-handed tactics to which she was subjected on June 22nd, to a degree that he prepares a very detailed affidavit outlining it all, actually, and she testified at a voir dire hearing and went into this, recounted it again under oath. And so at that point, trial defense counsel is aware that that's been going on at her expense, involving her son also at her expense, and he finds that out 6 days before trial.
But he doesn't do anything with it.
Nothing.
But maybe,
and so-
why can't we say that that was a strategic decision on his part?
I don't, given the consequences of what happened here, given what we now know, that all of that was clearly part of the, should have been considered as part of the totality of the circumstances, clearly addressing the voluntariness of that statement that he gave on June 23rd.
But we learn all that at the motion for a new trial, and the judge makes credibility findings that there's no communication of this to the defendant before he incriminates himself voluntarily. So I'm at a loss of why any of this matters, given that it's already tested at the motion for a new trial pursuant to an evidentiary hearing by the trial judge, who was the motion judge, right?
Yes, Your Honor.
Yeah, I mean, I understand but it seems like the judge's credibility and fact-finding makes that, it may have been ineffective in the sense that, I mean, it may have been error not to pursue it, but it's meaningless according to the judge's findings.
I would respectfully suggest the following, Justice Kafka. I will concede that point for the sake of argument, and that, if I may, that there was no clear error with respect to the judge's findings on that particular point.
Right.
I'd respectfully suggest that his determination of the credibility on the specific point that Adalia Castro didn't go into all the details about, we're going to lose our twins. It didn't go into specific details about what was being done to her, was not communicated during that phone call, and that both she and Mr. Cologne are not accurate when they so recount that. And I respectfully suggest, well, with all due respect, I'd say, so what? Because we got to look at this in the context of what was going on. What we do know did not happen here and could have happened is that, notwithstanding those findings of non-credibility, there was still a lot more that could have been and should have been submitted to this jury for them to properly do their constitutional, their required responsibilities to assess the totality of the circumstances. And that's unfortunately what has happened here in this case. Unless there's any other questions, I'll submit my brief, and I thank the court for its consideration.
Thank you. Ms. Semmel.
Good morning, may it please the court. I'm Catherine Semmel on behalf of the Commonwealth. And Justice Kafka, in answer to your comment, no, I don't think there's any way to undo Judge Welch's findings on this point. I think they were ironclad. I think he could have discredited the defendant's post-conviction claims on their face, but instead, after a full evidentiary hearing, he listed numerous reasons why he didn't credit them. And I won't go through them all now, they're outlined in my brief, but certainly among them is the fact that he had two competent counsel who vigorously, you might even say exhaustively, litigated the voluntariness of the defendant's statement to police. There were three separate motions brought by first one and then the second counsel in this case, none of which mention the phone call between the defendant and Ms. Castro. Such phone call did take place. The record of the first June 22nd interview makes it clear that it was at the defendant's request. It was not a ploy, and Judge Welch made a specific finding about this. The defendant asked to see his wife, which is what he called Castro, and the officer said, no, but you can speak to her. And then allowed him to do that with cell phone conversation. So it was clear that there was a cell phone call. Mr. Silverman knew at the time of trial that Ms. Castro claimed to have been threatened by police, and vigorously litigated the voluntariness of the defendant's statement. And so in that context, the defendant's assertion now that he made the statement on June 23rd, that he confessed to a murder he didn't commit solely because his girlfriend had conveyed threats to her, to him, fell flat for the trial judge.
The defendant, I guess, is now making a more focused argument. All that's I understand all those arguments, and they're compelling arguments, but he's making a little bit more focused argument now, which is that whatever Judge Welch might have thought, that the defendant could have put enough evidence in through this telephone call to get a humane practice instruction at trial.
He did, in fact, get a humane practice instruction at trial. With that added evidence.
With that added in. And so he's sort of, I mean, it's less of an argument than before, but that's the argument that we heard today.
In his
You
reply
understand
brief.
that? Right.
So a couple of things about that. The first is the obvious weakness of that argument, that he confessed to murder because his girlfriend was upset and crying on the phone the night before. I'm sorry, I completely lost my train of thought.
No, that's okay. It's just, it's interesting, though, because, you know, on the one hand, you have all the issues about why the police weren't engaged in anything that was based on Judge Welch's findings, but that doesn't preclude the defendant from presenting that evidence to the jury and having the humane practice instruction maybe have the jury believe that the confession was not voluntary and not considerate.
That is true. I remembered my list.
I knew that
should
would,
never say first. So a couple of problems with that is first of all, neither Adalia Castro nor the defendant testified at trial. The defendant has posited no theory as to how that evidence would have come in without their testimony. Presumably, they didn't testify for good reason. The defendant doesn't challenge counsel's failure not to produce them as witnesses. Certainly, Mr. Castro had a record and had confessed. I'm sorry, Ms. Castro had made inculpatory statements, and the defendant had a record and had confessed. So unclear how any of that evidence would have come in without doing severe damage to the defendant's case as he had it. Second, just from an evidentiary standpoint, the strength of that argument is really undermined by the fact that in that June 23rd statement, the defendant made no mention of Ms. Castro, made no mention of his concern for her, for their unborn children, for any of these things that he now says led him to confess to murder. He said he wanted to go home, is what he said. And yes, in answer to Justice Lowy's point, it's not entirely clear that he realized just how badly he was implicating himself in the offense, because he seemed to keep asking, can I go home after this? But I don't think you need to get there. I do think that this secondary argument that this could have just been presented, that he had a phone call with his girlfriend and she was upset, just didn't have any strength.
I think defense counsel, at least as I understood what he was saying today, is not only would I have been able to introduce the evidence that she was upset and told me to cooperate, but he would have introduced the evidence that the police picked on her and did all this manipulative, coercive questioning of her.
Well, that's
so
what
that he
Judge
would've-
Welch said didn't happen. I'm sorry, that's what Judge Welch said was never communicated as a matter
Right,
of
but
fact.
I think he's saying today, but I may be misinterpreting him, saying that when he's talking about the totality of the circumstances, you would have, even if you accept Judge Welch's finding it's not communicated to the defendant, all this information would have given you a flavor of the police behavior that might have influenced the jury on the voluntariness finding. I think that's what he was saying today.
I didn't get that from the argument, but it's just not a particularly strong argument. Assuming that he had witnesses who were going to put in this evidence even, which is, as I said, the first problem.
So he knew, but by the way, he knew, who knew 6 days before trial about this course of questioning? I'm just trying to make sure I understand.
Mr. Sobelman, Attorney Sobelman is the one who brought the motions regarding Ms. Castro. And I'm sorry,
6 days before trial?
I think, I didn't remember the timing, but I know that it was shortly before trial that he spoke with her. He completed an affidavit with her that made no mention of the phone call, but that talked about the fact that she had been threatened by police. And if I could just correct one thing, which I'm sorry, it's kind of a sidelight, but it was raised in the defendant's reply brief in a way that was critical of the Commonwealth and was raised here today. And I would just say that on the first day of trial with regard to the Fifth Amendment issue of Ms. Castro, Judge Welch did not make a finding that in fact there had been threats and coercive actions on the part of the police. What he said, and this is at pages 204 to 205 of transcript 1, what he said was that he didn't think that she had a Fifth Amendment privilege because if she testified consistent with her statements, all she would be saying was that she was coerced into making false statements by the police, and that in his mind that was not severe, that was not enough of an implicating factor that she could ever be tried based on that for making false and misleading statements to the police. He didn't.
Another way of saying it is that at the Martin hearing, he's not finding what she said was true or not true. He's making a finding of what she's going to testify to is not going to incriminate her.
That's exactly right. Thank you.
But
Yes.
how could he have found that if she was going to say, I was going to deny the substantive information that I've told the police earlier?
If that's what she was claiming she was going to do.
Okay, so I'm a little bit confused. So she says, I've got a Fifth Amendment right because I'm going to recant what I told the police. And I thought that Judge Welch had found, well, her recantation would not subject her to any risk of prosecution because the conduct of the police during the course of the interview was such that no one could blame her for recanting. Is that not a fair description?
He is not saying, he's not making that finding as a matter of fact. He is saying that that's what her statements would say. That's what she would say. And that would be the
That
thrust of
reflects
her
how he then,
statements.
how he then goes on to say that she has no Fifth Amendment right if the police could say, well, she testified to X, but she told us Y.
I'm not sure about the legal correctness of Judge Welch's thoughts, but I'm very sure about what he said at the hearing. And that what he did say was that her statements on their face would not incriminate her at pages 104 to 105.
And is the Martin hearing part of our record or not?
Is what? I'm sorry.
Is the Martin hearing part of our record, or is his findings
Yes,
part of
it
the
is all
record?
part of the record, and Mr. Sobelman was present as far as I can tell. And there was, in
Really?
fact,
He was present
I believe so.
for the Martin hearing?
I believe, yes. I believe Mr. Sobelman is the one who brought forward the Fifth Amendment issue
But she
to
had
begin with.
separate,
But she had
but she had
counsel.
separate counsel.
She had counsel.
And they're
And
not
then-
usually allowed in the room either, are they?
I beg your pardon?
They're usually allowed in the room at a Martin hearing?
I don't know the answer to that, I'm sorry.
Okay.
I have limited experience with them. The next day, there was in fact another hearing, a hearing on the defendant's argument that her statement should be excluded because of these claimed threats by the police. And the judge, at the end of that, which there was testimony from various people, and the judge at the end of that credited various parts of her statement, such as that she was pregnant, but did not explicitly credit anything about the threats that were made, and at the end found that there had been no coercive police conduct so as to render her statements involuntary. What happened then was that the judge made very clear, however, that if Ms. Castro testified, that she would certainly be free to, or the defendant would be free to question her with regard to what she claimed were improper police tactics. And at that point, the Commonwealth declined to call her as a witness, and the defendant didn't call her as a witness. So I'm sorry, it is a complicated and tortured history.
If I could turn you to the DG and Batista arguments, am I correct that the June 22nd interrogation was not admitted at all into evidence?
That's correct. It really only became an issue post-conviction.
Okay, so the jury would have no reason to receive a DG and Batista regarding the June 22nd because they didn't hear it.
They didn't hear it, that's correct.
June 23rd, I gather the evidence is that the state trooper gave him Miranda but did not record it until after he had done that.
That's correct.
And you agree that he would have been entitled to DG and Batista with regard to that failure to record?
I do, and I don't know if it was as clear back in 2014, because I think cases came out after that that made it clear that we're really talking about the entirety of the interrogation. But yes, I do think he would have been entitled to it. And Judge Welch did address this. This was raised in the motion for new trial. And Judge Welch did address this, and he had a number of reasons why, even though probably entitled to it, he did not think that it gave rise to a substantial risk of a miscarriage of justice under his standard, I guess. But prime among those was the fact that the defendant initiated the contact between the police and himself on June 23rd. And those were also findings along that line were made by Judge Liu in the motion to suppress prior to trial.
And had defense counsel asked for a DG and Batista instruction or not?
That is another very confusing, tortured
Torturous,
history.
torturous,
I'm so
huh?
sorry. So in his written request for instructions, Mr. Silberman included a DG and Batista instruction. In the charge conference, Judge Welch, at transcript 4, page 126, made a comment, sua sponte. He said the lack of tape recording is not an issue in this case, as he was going through Mr. Sobelman's request. Mr. Sobelman didn't say anything at this point. The instructions were given. There was a humane practice instruction. There was no D. Giambattista instruction. And then after the final charge, Mr. Sobelman did raise an issue with the judge, not about the failure to record the beginning of the 23rd, but due to the fact that Trooper O'Connor had mentioned in his testimony that he also spoke to the defendant on June 22nd. And Judge Welch's theory was that it was not all part of the same interrogation. It didn't, D. Giambattista didn't apply to statements on a different day. And then just the climax to the confusion, Mr. Sobelman states on the record, you did give a D. Giambattista instruction. And this is all happening at transcript 5, page 103 to 105. So yes, he did preserve it originally, generally, but he did not preserve it certainly as to the failure to record the beginning of the June 23rd statement. And I would leave it to your discretion whether you feel like he preserved it as to the June 22nd that was not recorded.
But the part that was recorded, how long was the interview?
Oh, I don't remember. I'm sorry.
But we have
I
it.
would just be guessing. Yes, you do. You have the audio, which I believe, I'm sorry?
Was it a video recording or only audio?
It was an audio recording that you have.
Isn't most of the argument about D. Giambattista not about the recording of the confessions, but not recording the telephone call?
In the defendant's brief, that is what most of the argument
Really,
is about.
and there's no requirement to record the telephone call, is there?
No, it's definitely not part of the interrogation, and I think the defendant's argument that it is part of the interrogation depends on him persisting in suggesting that it was all part of a nefarious plot on the part of the police, which is counteracted by the June 22nd interview when the defendant asked to speak to Castro, and also specifically by Judge Welch's findings, which I believe are in footnote 2 of his decision.
Right, but the whole purpose of a D. Giambattista instruction is to tell the jury that you, on that basis alone, may find the statements to be involuntary, but it is implicit that the statements were heard by the jury.
Yes. Yes,
So
Your
it's
Honor.
hard to ask for a D. Giambattista instruction with regard to a date of interrogation that was not furnished to the jury.
True. Yes, Your Honor. I would just say with regard to 33E, that the defendant's conviction in this case was certainly consonant with justice. He told the police that he was the lookout in this case. He told his friend in jail that he was the one who actually shot and killed Juan Caba and injured Amanda Foxworth with that same shot. His being a lookout was sufficient for felony murder, but certainly the possibility that he was the shooter was also well supported in this case, and under either theory, he was heavily enough involved that the conviction in this case was perfectly just. The court has no further questions. I'd be happy to rely on my brief.
Okay,
Thank you.
Court